Thank the NRA? Well, it is a decision that the NRA won before the Supreme Court, a unanimous decision that is now the greatest weapon for Harvard and those big law firms who are all challenging Donald Trump. And that case that went for the NRA is now succeeding in protecting the First Amendment rights of those who are being targeted by Donald Trump. Let's discuss. I'm Dave Aronberg, former state attorney for Palm Beach County, aka the Florida LawMan, here on Legal AF. Thanks for all your support. Thanks for the likes. Most importantly, thanks for hitting that subscribe button. Let's keep the momentum going. Get us to over 700,000 subscribers. We appreciate your support. Now let's talk about how a Supreme Court decision not too long ago that backed the NRA, National Rifle Association, is undermining Trump's attempts to punish law firms that oppose him, including Harvard and other universities who challenge Trump. Now, a lot of universities, a lot of law firms, they are capitulating or staying silent, but the ones who have fought back are using this unanimous decision by the U.S. Supreme Court that went for the NRA, and it's working. And so it is kind of amazing that this case, which seemed as a big victory for the right wing of our country, it was a 9-0 ruling with Sonia Sotomayor, the liberal justice, writing the opinion for the unanimous court. Well, that is now flipped on its head, and now it's being used in just about every legal brief and just about every legal decision that Trump loses when it comes to Harvard or all those law firms that have fought back. So, according to CNN, as Harvard University, elite law firms, and perceived political enemies of President Donald Trump fight back against his efforts to use government power to punish them, they're winning thanks in part to the National Rifle Association. Last May, the Supreme Court unanimously sided with the gun rights group in a First Amendment case concerning a New York official's alleged efforts to pressure insurance companies in the state to sever ties with the group following the deadly 2018 school shooting in Parkland, Florida. A government official, liberal Justice Sonia Sotomayor, wrote for the Nine, cannot use the power of the state to punish or suppress disfavored expression. A year later, the court's decision in National Rifle Association of America versus Vullo has been cited repeatedly by federal judges in rulings, striking down a series of executive orders that targeted law firms. Lawyers representing Harvard, faculty at Columbia University, and others are also leaning on the decision in cases challenging Trump's attacks on them. For free speech advocates, the application of the NRA decision in cases pushing back against Trump's retribution campaign is a welcome sign that lower courts are applying key First Amendment principles equally, particularly in politically fraught disputes. Now, this is where Trump's own words get him in trouble. When he says, I am your retribution, when he makes it clear that he's going after these law firms because he doesn't like that, say, Robert Mueller came from this law firm or Andrew Weissman came from this law firm. It's clear that their motivation is retribution. And that just walks right into this opinion, because in this case, the NRA case, the NRA claimed that Maria Vullo, who was the former superintendent of the New York State Department of Financial Services, had threatened enforcement actions against the insurance firms if they failed to comply with her demands to help with the campaign against gun groups. The NRA's claims centered around a meeting Vullo had with an insurance market in 2018, in which the group said she offered not to prosecute other violations as long as the company helped with her campaign. And that is the beauty of the First Amendment. It's not partisan. It helps everyone. And those liberal justices who were probably criticized by some on the left for joining with the conservatives, joining in a decision that helped the NRA, they were playing the long game. They clearly saw that if they can set up precedent here, it could benefit the First Amendment in other cases where liberal groups may not be as popular, or maybe the target of a out of control chief executive. The impact of Vullo can be seen most clearly in the cases challenging Trump's attempts to use executive power to exact revenge on law firms that have employed his perceived political enemies or represented clients who have challenged his initiatives. See, this is why the law firms that are pushing back there, that are spending lots of money and risking a lot of their reputation and a lot more to challenge the very powerful White House, this is why they win in the end. This is why they prevail, because as they fight in court, they keep winning. And their clients may not be thrilled that they're at odds with the White House, but their lawyers are, their employees are, their partners are. We've seen for those firms who have capitulated that prominent members of their law firm have left. They have gone elsewhere. Students at schools may not want to go to those schools that capitulate. This is why it's a good move in the long run to at least stand up for your principles, because if you capitulate, it looks bad, not just in the history books, but also for the employees. And yeah, there are probably clients who probably don't want to be associated with a law firm that looks weak. After all, you've hired these prominent litigation firms to fight. And if their first step is to cower instead of fighting, well, not a good look. So I understand why some of the law firms did it. Some of the law firms did it because their clients are saying, we don't want to be at odds with the administration. And so they decided, but that's the short-term decision with long-term pain, because over the long haul, I think those firms that fought back are going to end up winning. And they're winning in court, according to CNN. Across more than 200 pages of writing, the judges, all sitting at the federal trial level court in Washington, D.C., cited Vullo, that NRA decision, 30 times to conclude that the orders were unconstitutional because they sought to punish the firms over their legal work. The judges all lifted Sotomayor's line about using the power of the state to punish or suppress disfavored expression, while also seizing on other language, in her opinion, to buttress their own decisions. And it's not just judges appointed by Democrats that have ruled this way. You've got them on different sides. This is why the judiciary has been the guardrail against authoritarianism, because as Congress emasculates itself, for the first time in history where Congress just gives up its power to the executive branch, the judiciary is standing strong. We really shouldn't have been that surprised. I mean, the judiciary has a tradition of bucking up against the executive branch. I mean, they get lifetime appointments if you're a federal judge. You get to wear the black robes, you get to carry that cool gavel, slam it down, and everyone has to stand up when you walk in the room. Try doing that if you're a member of Congress. People aren't standing up for you. In fact, people probably throw things at you. According to CNN, two of the judges most recently, that's Beryl Howell, that's an appointee of President Obama, and Richard Leon, who was appointed by George W. Bush, incorporated Sotomayor's statement that government discrimination based on a speaker's viewpoint is uniquely harmful to a free and democratic society. And the third judge, John Bates, said Vullo, that's the NRA decision, and an earlier Supreme Court case dealing with impermissible government coercion govern and defeat the administration's arguments in defense of a section of the gender and block order that sought to end all contractual relationships that might have allowed taxpayer dollars to flow to the firm. So, you know, even though DOJ in their response is saying, well, this is different. This is what Trump is trying to do here with the law firms is different than what the state of New York tried to do the NRA. The courts are rejecting that. They're saying, no, it's a distinction without a difference. It's the same thing. You can't discriminate against people because you don't like them. You can't have retribution against your political enemies. The First Amendment doesn't work like that. It's not partisan. It's not to be used as a weapon for the party in power. And so the courts keep pushing back and these law firms keep winning, and they can thank the National Rifle Association for it. Someone should tell President Trump that it was the NRA that caused so many legal defeats. 9-0. When there's a 9-0 ruling at the Supreme Court, the lower courts take notice, and so do the plaintiffs. So that's the latest. I'm Dave Aronberg, aka the Florida LawMan, here on Legal AF. If you like this video, please like, subscribe, share with a friend, leave a comment below, and hit that subscribe button. I don't know if the button just came up here, but I think it is. It should be right here. Hit that subscribe button, and I'll see you next time.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.